We're going to have some fun today, ladies and gentlemen. This is Focus on Retail, episode number 1 of the Financial Poise Chapter 11 Industry Focus 2024 webinar series. I am now sharing my screen, and you can follow along as we have our conversation. There have been a lot of retail Chapter 11 filings this year. Slide 11 notes just a few of these. 99-cent stores, The Body Shop, Express, Joanne, Route 21. Those are some of the more better known companies that have filed. Our panelists are Mark Joachim, James Sullivan, and Jonathan Warnick. My name is Jonathan Friedland. I am today's moderator. You can see that we've, again, displayed the slide deck, and you can download it. If you study slides 39, we want you to study them, 39 through 42, you can see that 3 of us are lawyers, and one of us, the other Jonathan, is a financial advisor. Financial Poise doesn't allow us to talk about ourselves. They don't want you to sit through infomercials. So we'll just have to impress you with our performance today. Do be sure to look at slides 43, 44, and 45, which we won't talk about other than, I guess, right now for a second. Daily DAC offers a wealth of resources to both restructuring professionals and non-restructuring professionals who are interested in restructuring. Couple of good, I'm highly biased, treatises on bankruptcy and bankruptcy alternatives are highlighted on slide 44. And slide 45 is a slide about the producer of the series, Financial Poise. You'll notice that I'm turning to and verbally identifying the slides that I'm talking about. I'm going to try to keep doing that throughout so that you can follow along and take notes on the slides if you want, that kind of thing. Just a couple of last housekeeping points, and we can dive right in after that. Slide 5 is a disclaimer. It reminds you that you are not our clients. We are not your advisors. What we discuss here and in the slide deck is for your general edification, not advice you should rely on without seeking actual real counsel from somebody who actually represents you. Okay, that is the housekeeping, so I can turn to our first question. And for this question, I'm going to turn us to slide 33, and I'm going to ask Mark. Mark, when a retail store is having a going out of business sale, why do I commonly see people holding up signs on the side of the streets around that store just outside the shopping center where the store is located?
Thanks, Jonathan. That's a great question. So just to give an overview on how going out of business sales work, oftentimes when a company files for Chapter 11 or retailer, one of its strategies is to pare down its operations. And in order to do that, one way to do that is a going out of business sale followed by rejection of the related lease, all of which we'll talk about later. But outside of bankruptcy, it's kind of difficult to do GOB sales, right? Because there are various state and local laws that govern them. There's also lease requirements that are binding on a tenant. There may be shopping center type rules to protect the different tenants from having too much GOB activity within the shopping centers. So, but what the bankruptcy code does is it overrides a lot of that. A bankruptcy court does have the authority to approve a going out of business sale that doesn't necessarily comply with the lease terms and with state and local law. Although what a bankruptcy judge will try to do is to balance the interests as a court of equity, balance the interests among the various parties, and they will put certain restrictions on the ability to do GOB sales. They might require the signs to be held outside of the shopping center. They will certainly enforce or require enforcement of things that relate to health and safety. Obviously, a bankruptcy judge is not going to override state and local rules that could affect health and safety. But other than that, in order to give a debtor the ability to do this in bankruptcy, a judge has the power to override many of the rules. GOB sales generally take, somewhere around 120 days to consummate, and to do. We'll talk about this later, but debtors only have at the most 210 days within a bankruptcy case to decide whether to assume or reject leases. And so all of that needs to be taken into consideration on timing when you're doing GOB sales.
Thank you, Mark. And audience, I did turn us to slide 35 as Mark was talking about the uh, landlord prohibitions. So panelists, and I'll do this for every question, is there anything that comes to mind as Mark was answering the question that you want to overlay? Anything at all? Okay.
This is Jonathan Wernick, and I would say they're also trying to create a circus, and that's why you'll see the guys with the signs creating all kinds of interest, because you want to lure people in as much as possible. Sometimes someone never wanted to step in foot in the store, but now they're saying, oh, there's a bargain, it's 40% off, I'll try it. Now, yes, it does cheapen the image of a fine shopping center, but at the same time, it's luring in customers, and maybe they'll stop at one place and then another. So there's a win-win, I think, for everybody.
Also, to directly answer your question, Jonathan, the guy is probably standing outside the shopping mall area, so which is outside the lease, right? So you can get away with it.
Right. Guys, the producer just handed me a note. I forgot to mention our sponsor, so really quickly, slide 3, Mood. Anyone in most states can buy legal cannabis online now. That's Mood. And if you don't know anything about cannabis law, I know that may surprise you, but that's a whole different webinar. And slide 4 has the 2 other sponsors for this series, for this episode and for the entire series. Type 2 Learn is what it sounds like. It's for kids, and parents can buy, it's like K-4, K-6. It'll help give kids an edge in typing. And then Max Asset is a little bit more germane to most of our audience. It's a platform where trustees, receivers, assignees, without having to go to the expense of hiring an auctioneer, can build. Well, not build, but it's out of the box turnkey auctionware that is fairly inexpensive. Okay, back to the program, and I'm gonna award this question to Jonathan. Let's say I go into a retail chain that's having a GOB sale, going on a business sale. I'm looking for bargains. It's a location of a company that I know has filed for bankruptcy. I've been to the store many times. I'm pretty familiar with what's in the store, kind of things it carries. And before the bankruptcy, like in the weeks and even maybe the months before the filing, the store looked pretty empty. Shelves weren't being restocked. But now, today, I walked in and the store is absolutely filled to the brim with stuff, including a lot of stuff I've never seen the store sell before. What's going on?
Well, first off, there's a timing of when retail goes into bankruptcy, and it's usually after the holidays. So they've sold through whatever they could, all the good stuff. So that's one reason why it's empty. And then they've been running out of cash. So they've been trying to reduce as much as they can as far as payouts to vendors. But I think when you say there's new stuff, that bothers me as well. But it's really a great thing for liquidators. It's a concept called augmentation. And augmentation is a departure from like kind and quality inventory of goods. And they're brought in during a going out of business sale. The landlords don't like this because it disrupts the curated balance of offerings that other tenants bring to the shopping mall. And some examples of augmentation. I did a music store and a bookstore, and so all of a sudden they're selling hand tools and blankets and stuffed animals and kitchen supplies. One funny story with augmentation. So one of the bookstores was a Christian bookstore, and these stuffed animals came in as part of augmentation, and they were purple with the sign of a devil. And you think about this for a Christian bookstore. And so all the employees were going, man, we can't even get bankruptcy right. needless to say, those weren't sold in the going out of business sale. And so there's several reasons for augmentation. One is it makes the store look fuller. You want to encourage several visits by customers because they want to see something new. And lastly, the augmented products have a really good margin. Now, maybe it's time to talk about liquidators like Hilco and Great American, which is now called B. Riley Retail Solutions. And that's part of my group. They're like a sister group to me.
I turned to
And
a slide 34 audience.
so the liquidator disposes of all the company's assets, and after paying the costs and expenses of the liquidation, they distribute the remaining money to the creditors. It's a quick and efficient way, and each store remains open. As each store remains open, there's salaries and rent to pay and other expenses like insurance. And so a good liquidator knows how to time the discounts, commonly referred to as a cadence, to maximize the proceeds. Because some people say, why do you need a liquidator? We'll just say 50% off. And you're going to give away lots of margin when you do that. So instead, usually the first few weeks, it's maybe 10% off, but because there's a circus-like environment, people are excited to go in and think they're getting a deal because it's going out of business. There are times where like a liquidator will assume all the costs of going out of business, including the advertising, the lease expenses, and the payroll, and will pay for it through the proceeds of the sale. Now, the one thing that liquidators really know how to do well is to market the sale. And they do that through signage, as we spoke about before, sign walkers alerting the public of the sale, using social media and email campaigns, radio and TV ads, although that's less likely now. And they create what's called the circus environment. I can't say that enough, where people believe it's the greatest sale on earth and they don't want to miss out. There's that FOMO aspect.
Thank you. Guys, overlay. So as Jonathan mentioned, and these liquidation firms like a Hilco, like the firm formerly known as Great American, like a Hyper AMS out of Chicagoland, this is what they do. They do other things too, but they're expert at this. And I just wanted to kind of put a finer point on one thing you said, Jonathan. Sometimes they act as agents. They're liquidating agents, and sometimes they take principal risk. They'll effectively buy the goods in question and effectively lease the stores. That's not the language that's used in the legal agreements, where the typical term of art is they call it a quote unquote guarantee deal. But it has many of the hallmarks of an outright purchase because they're taking the economic risk. It's a whole cottage industry, in and of itself. There's the corporate restructuring, insolvency, bankruptcy profession, and then a very small subset of that profession has this cottage industry of these liquidators. And actually, even the knowing how to negotiate the agreements between the liquidator and the debtor is also sort of a very cottage niche practice. Most bankruptcy lawyers don't know how to do it because most bankruptcy lawyers just don't have caught, it's usually within a big firm, it usually works out that work typically keeps going to the same few people. And so they become expert at it. But it's a very bespoke type of agreement that either you've done a lot of and or you don't. Anyway, I'll move us on. By the way, before I present the next question, and I'll give James fair warning, it's coming to you. I'm displaying slide 12 for a moment. This slide is unchanged from the version of this webinar that we did last year because nothing has really changed a whole lot. And so these bullet points as to what the heck is causing all of these retail filings, I don't know that any of this has changed, and I don't know that there's any new, macro factors. I think this is fairly comprehensive. Guys, do you want to overlay? Do you see something that's missing or that's no longer true?
Well, inflation maybe is a little bit more prominent now than it probably was before, so that may play into some of it. But other than that, oh yeah, you have that there. Sorry.
I do.
But I do think it's more prominent now than it probably was a year ago, and 2 years ago.
And the internet's still a thing.
Yeah.
So,
Yeah, but I would say also, Jonathan, that there's no longer the government program. So we don't have PPP, we don't have
right.
EIDL loans, we don't have the employee retention credits. There's no more handouts, for lack of a better term. And because of that, the lifelines are gone. And I think also the banks are being pushed harder now to start to make a move, as opposed to before, where they would delay, extend, and pretend is what the term was.
And you trade the inflationary pressures that government handouts were causing have now been traded. There's been a lot of the minimum wage in states has moved up an awful lot in the last couple of years since COVID. And a lot of retail, people working in retail make that minimum wage. Anyway, enough of that. Like I said, James, you got the next one. I'm gonna change hats. Now I'm no longer a consumer buyer looking for bargains. Now I'm Larry the landlord. I learned that a retailer who is my tenant in 4 different locations just filed Chapter 11. I own 20 strip malls, and I've got the same retailer at 4 of my locations. Just found out filed Chapter 11. Tell me a little bit about actually tell me this. How did I likely learn about the bankruptcy filing?
Well, when you file for bankruptcy, one of the things that the court rules require you to do is notify all your creditors. So, that may take a few days, but they have to file what's called a bankruptcy petition, as well as a list of their creditors and, at some point, a notice of commencement of the case. But aside and apart from that, sometimes it takes a little while, but they may read about it in maybe in the newspaper or in a journal. They may find out from their bankruptcy attorney or other attorney that's monitoring the new cases. So there's typical ways that they'll find out about it.
Who will overlay? So I want to overlay. So I remember I'm Larry the landlord, and I've never been bankrupt. My companies have never been in bankruptcy, so I don't have bankruptcy lawyers per se, but I have lawyers. And my law firm has I don't really think about it, but it's a big law firm with lots of different practice groups, including a bankruptcy practice group. And what commonly happens is whenever there's a filing, all of the different bankruptcy groups that across the country within law firms that chase creditor committee representations will ask their colleagues and look in their conflict search databases to find out. Well, they take the top 20 list that you referred to, and they look at who's on it, and then they may search their client database, and lo and behold, they find me and maybe some other company that the law firm represents, and the lawyers who do the bankruptcy work might ask my real estate lawyer, hey, would you make an introduction to Larry the landlord? Because he may want to, you should let Larry the landlord know about the filing, which is a good deed. It's doing a solid, but there's also a selfish motivation because Larry the landlord might need representation in the bankruptcy, and maybe, just maybe, Larry the landlord is interested in sitting on the official committee of unsecured creditors. So there's that whole angle too. So let's continue down the line of I'm Larry the landlord. Jonathan, I'm going to give this to you. And again, I just learned about the Chapter 11. What are some of the basic things I should do and basic things I should expect to happen pretty quickly, regardless of who the debtor is, just generically? What am I typically going to experience as Larry the landlord in a Chapter 11 of one of my tenants?
Well, one of the most important things is that you're going to get paid rent. And it was interesting, like movie theaters during COVID probably got hit the hardest. No one was going to them. But you didn't see many file for a Chapter 11 restructuring. And the reason why is they'd have to pay rent during this time. And the numbers just wouldn't work out to pay rent when no one was showing up to the movie theaters. So that's the first thing. You're in a good place for at least current rent. Future rent and back rent is another story. But there's going to be a lot of motions on the first day requesting certain things, like there's going to be a going out of business sale, retention of liquidators. There might be an appointment of a creditors committee. There's going to be sale procedures and for designation rights. There's going to be a motion for critical vendors because certain vendors are still going to have to be provide commerce. There's going to be a motion to pay all the utilities, a motion to use the cash collateral that's available, motion to pay off pre-petition payroll. There's going to be a motion for financing called DIP financing. And the one I like the best is the motion to use the cash management system. A lot of times in bankruptcy, they say, okay, close all the bank accounts and let's move on to a new bank account. But when you're a retailer, you've got to point the sales system, you've got credit card processing, and it's really hard to move the pipes to new bank accounts right away. And so this is the one I really enjoy, is that there's a motion to make sure that the cash management system stays in place. Another one is employees. All the good employees, you want to keep them. So there's retention bonuses. Next thing you may have to worry about is reclamation claims, because people who have sold inventory just prior to the bankruptcy are going to want to get that money back. And I think as a landlord, you want to be very concerned about lease rejections. And the lastly is gift certificates and other loyalty programs would want to be maintained.
Great. I'm not going to ask for an overlay on this question because Jonathan did a really good job of sort of teeing up a whole bunch of strings, and now we can pull each string individually, if you will. I will note, by the way, I represented like about a dozen unit movie theater in the midst of COVID.
Oh, wow.
And it's a whole, it would, I don't want to distract from the agenda, but it was a very successful case. The landlord didn't have a lot of negotiating leverage, and we reorganized the damn thing. But that is the exception, not the rule. So now I'm going to turn us, audience, to slide 20. And I'm going to ask Mark to help us. Let's start to unpack some of the things we just learned from Jonathan. I'll ask this question of Mark. How, as Larry the landlord, can I make sure I get paid for post-petition rent?
Great. Well, first, I think it's important to distinguish, and I think the other Jonathan touched on this, but there's a distinction between pre-petition rent and post-petition rent. Pre-petition rent, when a company files, is just an unsecured claim. It's a general unsecured claim. It'll get dealt with under the company's plan or however it otherwise emerges from bankruptcy, if it liquidates or whatever. Just a general unsecured claim, and that's on par with all the other general unsecured claims. Once a company files for bankruptcy, post-petition rent, there's a requirement in the code that the debtor timely perform its obligations under its leases and contracts after it files its bankruptcy petition. So, this was a massive issue during COVID, obviously, because as mentioned, a lot of these companies just couldn't afford to pay rent post-petition. And what I would say is that when you're looking at cases from that period of time, keep in mind that COVID created some pretty unique decisions by a lot of bankruptcy judges. The rules I'm about to talk about were not always enforced because of the extraordinary nature of COVID and the fact that bankruptcy judges view themselves as courts of equity. But timely perform all your obligations under the lease. You've got 60 days in order to start complying with the terms of the lease. Sometimes you can get an extension for cause for another 60 days, but pretty quickly within the bankruptcy case, you've got to start paying your rent. And if you don't start paying your rent, then the landlord can go into court. Landlord can't just immediately kick you out for not paying rent because the automatic stay, the bankruptcy code applies. Need to go and get relief from the automatic stay, the landlord needs to, but if the debtor's not paying its rent post petition, in all likelihood, the judge is gonna permit the landlord to terminate the lease. There is an exception in terms of having to perform all the obligations after the bankruptcy petition. Obviously, the obligations related to not being insolvent, not being in bankruptcy, all of those defaults, they're in leases, but they're not enforceable in the Chapter 11 context. So, that is a big exception to the fact that the debtor's gotta survive under all of its leases. As I said, post-petition rent gets administrative expense priority. So to the extent that post-petition rent isn't paid, and then the landlord has to kick out the debtor and gets authority to do that, the portion of the rent that was unpaid post-filing would all receive priority and would be ahead of pre-petition unsecured claims.
Overlay, guys.
One thing that's probably worth mentioning is that, so a landlord there's a huge difference between a landlord that has a security deposit or perhaps a letter of credit as compared to one that doesn't. Having been involved in some very landlord centered cases where leases are being rejected. If you have a large enough security deposit or letter of credit, the landlord doesn't feel that kind of pressure to try to get the property back as quickly if it knows it's going to be paid. And, it will be prevented from the automatic stay from offsetting the security deposit against the rent that's owed without bankruptcy court permission. But with respect to a letter of credit, the issuer of the letter of credit is the debtor in that circumstance. So the automatic stay would not prohibit the landlord from utilizing the letter of credit to offset its damages. But I think it's worth mentioning that sometimes these landlords really stand in very different positions from one another based upon what kind of security or collateral that they have for the defaults under the leases.
Thanks. And one thing I want to add that I didn't make clear is that while the automatic stay prevents a landlord from terminating a lease during bankruptcy and you've got to get relief from the automatic stay, there is an exception to that, although in practice it's really hard to actually use. There's an exception that if you've actually terminated, the landlord had the right to terminate the lease and actually legally terminated the lease prior to the commencement of the bankruptcy, and that's the important part, actually terminated. Then there's an exception to the automatic stay and the landlord can evict. However, as you might imagine, there's often a difference of opinion on whether or not the landlord simply had the right to terminate the lease and whether they actually went ahead and terminated the lease. And to the extent that it's not crystal clear, a landlord is going to want to, at the very least, go to the judge, the bankruptcy judge, and get a declaratory, statement that the lease has been rejected, because the consequences and the damages that it could be put on the landlord to pay for a violation of the automatic stay, if it turns out that the tenant was right and it wasn't really terminated pre-bankruptcy, those damages can be really substantial, and there can be sanctions and the like. Violating the automatic stay is a very serious thing. So I had a case where this was litigated, whether or not a lease had been properly terminated, and as you can imagine, it makes a big difference, right? If it's a lease that the debtor likes and has an argument that it wasn't terminated pre-bankruptcy, while it's going to have to, when it wants to assume the contract, as we'll talk later, it'll have to cure all defaults. It at least has the option of continuing with that contract. If it was terminated, the debtor is either without that property or is going to have to negotiate without much leverage a new lease, because the old lease has fallen away. So this is an issue that does come up from time to time.
Something Mark said, I want to expound on. Yeah, and it wasn't really the point of what you were saying, but I think it's interesting. The interaction between state law and federal law. Because the question of whether or not the bankruptcy code controls whether a lease can be assumed or rejected, but it can't do so in isolation. It's gotta, there is no, the state law doesn't, excuse me, federal law doesn't govern property rights. That's the business of state law. And so the question of whether or not the lease was effectively terminated or not is a question of state law. And so you have the bankruptcy courts generally, but it's the bankruptcy courts that will answer the question, but they put themselves in the shoes of a state court judge and they say, what would a state court judge do in state X? And that's how federal bankruptcy law can interact with non-bankruptcy state law. We saw that earlier too. We didn't highlight it, but we referenced it implicitly because going out of business sales, as we talked about earlier, are heavily regulated at the state and at municipal level. Lots of cities have laws about going out of business sales to because there's a deep history in this country about basically a vendor or a retailer pretending to go out of business and having a sale, and then lo and behold he's back in business next week. And there was fraud in the early part of the 20th century over this, and that's how those laws developed. And as we said earlier, when those local laws conflict with the federal bankruptcy code, that's the basis by which the bankruptcy judge is allowed to say those laws don't count right now. And as we said before, the bankruptcy judge will not and cannot properly say health and safety regulations don't count. That's a different story. But if it's just about, the conduct of a going out of business sale. Anyway, before I become even more verbose, I'll move us on.
Well, Jonathan, I just wanted to mention, because you mentioned it, the best sign I've ever seen that sort of, was fraudulent was one that said going out and then in small letters for your, and then in big word business under it. Reddit is going out of business, but they were just going out for your business, whatever that means. So, that's why we've got rules.
Yeah. Oh, and for the academics among you, the security deposit versus letter of credit distinction, Jeopardy question, what is the name of the principle that separates a security deposit, which is not nearly as good from a landlord's perspective as a letter of credit? Anyone? It's the independence principle. Because when the landlord draws on the letter of credit, the landlord is, unless it's a cash collateralized letter of credit, the landlord is not getting money of the debtor. The landlord is getting the money of a bank. Anyway, we'll move on. So, James, tell us more. I'm going to turn us, audience, to slides 31st to 33, but the slides that are really implicated are 33 through 35. Tell us a little bit more about a motion to approve a GOB sale. Actually, tell us something about it, because we didn't really talk about the motion itself yet.
Okay.
What's the motion look like? Who are the people that will commonly object? What are those objections commonly? How would you describe those objections, and how are they commonly resolved?
Right. So, as previously mentioned, it's oftentimes a first day hearing, especially when we're talking about a business with inventory that is perishable, like a grocery chain or something like that. That has to happen very quickly. So the judge may need to enter emergent relief to allow this process to take place. Oftentimes, the agreement with the liquidator or agent or auctioneer, whoever is going to be doing liquidating, usually or oftentimes that's negotiated prior to the bankruptcy, if not very shortly thereafter. And there are time constraints, as Mark mentioned in his last discussion. There's a deadline by which a debtor must either assume or reject the lease, which is 210 days, subject to a short potential extension. But so there's a timeline. Otherwise, if the debtor wants to stay in there longer, or if the liquidator wants to stay in there longer, they're going to have to assume that lease, which in all likelihood is not going to make economic sense absent some kind of side deal with the landlord. So what does, just breaking it down a little bit, what's involved in this going out of business motion? What type of relief is going to be asked for? First and foremost, it's a sale process, right? So sales outside the ordinary course of business require bankruptcy court approval. So going out of business sale certainly would qualify as a sale outside the ordinary course of business. And what's included in there? Primarily inventory. It could also involve fixtures and equipment. It could involve the leases themselves. Sometimes these leases have value. And so, the liquidator may or may not be in charge of liquidating the leases as part of the going out of business sale, but it could happen simultaneous with it, or maybe as a second stage to it. What else? There's going to be a component to reject contracts and leases, that are no longer going to be needed as a result of the going out of business sale. There's going to be ability to abandon any assets that are remaining that can't be sold, and that are no longer of any benefit to the debtor. And then there's going to be a retention of any necessary professionals. Like I said, there's the liquidator, auctioneer, agent. They're going to have to be retained. And, so that kind of gets us to who's going to be objecting to these things. And first and foremost, in connection with the retention of the liquidator or auctioneer agent, the U.S. Trustee's Office reviews any retention applications very closely. They look at retentions of debtors counsel, committee counsel, and any other professionals engaged in the case. And there's some bankruptcy court rules that to relate to these things, and the local rules, as well as court guidelines that relate to these things. And one of the things that the U.S. Trustee's Office often will look at is oftentimes a liquidator will want to be appointed under 363 of the Bankruptcy Code, which is typically a little bit better for the liquidator, less requirements in terms of reporting and applications to get paid and the like. And the U.S. Trustee's Office likes, lots of disclosures, lots of reports and things like that. So they may want to push the liquidator to be retained under sections 327 or 328 of the Bankruptcy Code, which have all these additional burdensome requirements. So that's oftentimes one of the disputes I've seen in some of these cases, and I've personally experienced in connection with one of my cases where it really slowed down the sales process because the party that we engaged to run the process could not reach an agreement with the U.S. Trustee's Office. And, it really, I think, hurt the business a little bit because it just slowed things down quite a bit. So, obviously, if you can get the U.S. Trustee's Office involved, quicker in the process and try to get their okay to it, that will definitely help. Who else would potentially object to this whole process? State and local governments. As Jonathan mentioned earlier on, there are state laws and municipal laws that apply. Could be things dealing with blue sky, what days you can operate, time of day you can operate, other things dealing with signage, selling of gift cards and whether or not they're honored, the ability to potentially raise prices before you lower them and claim that there's a discount, all these other rules that apply. And the courts are a little bit all over the place on it. And so you sort of have to include language in the motion to address it. Usually the motion will try to take a fairly aggressive stance with respect to these state and local laws that, saying that the debtor and the liquidator don't have to comply with them. But, some judges tend to be a little bit protective, and sometimes just to resolve things, oftentimes the liquidator will have standing agreements almost with some of these states and maybe even municipalities to address some of these concerns, or maybe they'll enter into some side agreements with these governments.
James, one thing you said that's interesting is not that everything you said was interesting, don't get me wrong, but some of the types of objections that you noted might be made by government authorities are also the type of objection that might be made by the landlords themselves, right? Because and this is a little bit repetitive of things we talked about earlier, but I'm a landlord of a mall or a shopping center, and I've got in all my leases, the stores have to be open and can only be open from this hour to this hour. And I've given exclusivity to some tenants where I've agreed not to allow. I've got a bookstore, believe it or not. I still have a bookstore in my, they still exist, right? In my shopping center. And I promised in my lease to that bookstore, I won't allow any other bookstores. But geez, you debtor, you want to bring in as augmented goods all kinds of books. That's kind of it'd be a problem. And we're a hoity-toity kind of shopping center. We don't like a lot of signs, and you want to bring all kinds of signs. So the landlords, and they'll often in real life, they'll act as a group, not a formal committee, but the major landlords, particularly of indoor malls, there's not that many of them, right? And so they are well accustomed to working together and negotiating to a resolution of usually reasonable compromise. I'm going to move us on in light of time. This is a little bit of a frolic and detour, and it's certainly not unique to the retail context, but then again, a lot of what we're talking about is not absolutely unique. Jonathan, spend a couple of minutes and tell us about the official committee of unsecured creditors and why, as a landlord, why I might be offered membership on this committee, and why I might want to be a member or not of the committee. Take a couple minutes.
Sure. Well, I think the first reason is you want a seat at the table because it allows you to have a say in the narrative. I used to like to say control the narrative, but at least you have a say in the narrative as far as what goes on. But typically, the unsecured creditors committee is made up from a pool from the top 20 creditors. And off the bat, a lot of people fall off because sometimes it's like a sales tax, so they don't sit on the committee, or it's a law firm, they wouldn't sit on the committee. Yeah, but the goal is to have a representation of different types of unsecured creditors, and landlords is always in the mix. You'll always see Ron Tucker from Simon Properties if it's a large retail. He'll always be on the committee for some reason, which is good. I mean, he likes to have a say in what's going on. And it's actually very helpful because he's been through it more often than not and can help guide the others who don't have as much experience. Then you want to have other types like service providers, other suppliers, and they also want to have a mix of both the small company and the large company. One other thing on the committee is you're always going to aim to have an odd number, so they'll never have a stalemate. Now, it's a question of like, why? One of the things that unsecured creditors do is they file claims. And there's always a challenge of when do you file it? You file it right away, or do you wait until the deadline? There's arguments for both. The longer you wait, the more accurate you'll be. But also, the longer you wait, the more likelihood that you're going to forget about it and miss the deadline. And once you miss the deadline, you're out of the money entirely. It also, when you put a proof of claim right away, there are people that will trade off of these proof of claims and will pay you a certain amount ahead of time. And so that's sometimes a way for a creditor to get some money out as opposed to waiting a long period of time, because usually it will take at least 6 months, if not more, to get paid anything from a court case.
If I may,
Yeah.
one way in which the filing of a proof of claim relates very directly to the concept of sitting on the committee is so big picture, forest as opposed to trees, not retail specific, but any kind of a case. The committee is, as Jonathan said, it's solicited from among the largest creditors in the very earliest days of the case. How do we know who those largest creditors are? The claims bar date isn't going to be for months. The default in the first instance is the United States trustee relies on the information given to it by the debtor. And the debtor has the first opportunity to say, creditor X is owed Y dollars and creditor Z is owed W dollars. Well, if I'm a large creditor and I see that I was listed at an amount that I think is far less than what I'm really owed, I can file a proof of claim. And for purposes of selecting the committee, the U.S. trustee will pay more attention to the amount that the amount in my proof of claim than the amount listed by the debtor. In fact, the U.S. trustee doesn't really have a reasonable choice but to do that because of the way the code is written. So that's a thing. What else should we say about committees? Before we move on, again, big picture, for those in the audience who are less familiar with the world of Chapter 11, why is there a committee at all? Like, what is this thing? Like, why does it exist? And it exists because Congress, in its wisdom, it's not a Congress that is the current Congress, it's from many, many years ago. Congress decided that in any typical bankruptcy of reasonable size, you have a company, the debtor, who's very motivated to spend money to protect its interest, to advance its interests. You have a secure, most companies of any size have a secured lender that has a lien on all of its assets, who has loaned an awful lot of money. So you have two 800-pound gorillas in the room. The room is the courthouse where the bankruptcy was filed, so to speak. And then you might have, depending on the size of the company, you might have 100 vendors, you might have 1,000 vendors, you might have 10,000 vendors. And vendors are not the only kind of unsecured creditor. A lot of times customers are unsecured creditors and employees are unsecured creditors. So you've got it's a classic dilemma of, let's say a company has 10,000 unsecured creditors, each with an average claim of only $100,000, $100. $100 times 10,000 creditors. Any one creditor by itself should not be motivated to throw good time and money after bad. What are they going to go hire a lawyer to go to Delaware, New York, or Texas to represent them in their $100 claim? No. But the bank doesn't have that problem. The bank has a problem because it's owed a lot of money, but the bank is well motivated to spend money to protect its position. So that's what the committee is. The committee is it provides a representative body to look out for the interests of all creditors. The end. Not of the webinar, my little soliloquy about committees. Anyone want to overlay? No,
Yeah,
I'll move us on. Yes, go on.
One thing, which is that in cases where you don't have a creditors committee, the U.S. trustee tends to play a broader role, right? And they'll pipe up more often in terms of things that relate to precedents that they don't want to set in the court and the like. Once a creditors committee is appointed, the U.S. trustee is still a party in interest, but tends to take more of a hands-off approach because someone else is kind of watching things for unsecureds.
Thank you for that. I will reward you with a question. So Mark, I'll give you a penultimate question and then the ultimate question. The ultimate question is, tell us what designation rights are, and as a landlord, tell me why I care. But before you do that, give us a quick overview, reminder, refresher of the concepts of assumption, assignment, and rejection.
Yep, will do. So,
Slides four, starting on audience slides like 14 through 19 for this one.
yep, thanks. So, one of the things when you look at the bankruptcy code and you learn how it works, one of the things you start noticing is it really tilts the playing field in favor of the debtor, intentionally so, right? The goal is to give companies a breathing spell, automatic stay. It can get its act together, it can formulate a plan. The code gives debtors the ability to do a lot of stuff that it can't do outside of bankruptcy, not just the automatic stay, but other things too. And one of those things is that a debtor gets to cherry pick its agreements. It gets to decide, these I like, these I don't. The ones I don't like, I'm going to reject and leave those parties with, rejection damage claims, as if I breached the contract right before bankruptcy. They can have a claim for whatever amount that is, and that claim will get paid pari passu with all other unsecured claims. Or a debtor can cherry pick contracts and say, well, no, these contracts I like, and I'm going to assume. And we'll talk about what that means in a minute, but how you do that. But the other thing the code does is it gives the debtor an amount of time to make that decision, because there's a lot of balls in the air, right? It's probably negotiating with its bank. It's probably negotiating with its unsecured creditors. It's dealing with the other requirements of the bankruptcy code, and things that just sort of come up during a bankruptcy case, which, come up all the time. So you get that breathing spell, you get time to make a decision. You don't have as much time as you used to. When I started doing this a million years ago, you could just continue to get extensions on the time to assume or reject. And so because of that, and also because frankly, companies now have a lot more secured debt than they used to have. Back in the old days, companies had a lot of unsecured debt, very little secured debt. And the great thing about bankruptcy is you don't have to service your unsecured debt while you're in bankruptcy. So bankruptcy was a great place to hang out for 2 or 3 years, and just get a breathing spell and see if you could reorganize. Can't do that anymore. In 2005, Congress amended the code. Landlords have very good lobbyists, I assure you. And they were able to get a limitation on that, which is that you really only have 210 days. You've got 120 days. It can be extended for cause, which has to be shown, and the judge has to believe there's cause. But, you can get a total of 210 days to make that decision, but you've got to make that decision within that period of time. And if you don't, you're deemed to reject the agreement. You no longer have the decision to make. So I talked about assumption. What does assumption mean? You need court approval to assume an agreement. The judge has to believe that it makes sense for the benefit of the estate to assume the agreement. So you've got to put on evidence to that effect. When you assume everything, right? You can cherry pick agreements, but you can't cherry pick within agreements, right? You can't say, I like these provisions of the lease, but I don't like these. You've got to take the lease, warts and all, when you assume it. And when you assume, you've got to cure all defaults, right? And all monetary defaults and other defaults that can be cured. Obviously, you don't have to cure the one about being insolvent and being in bankruptcy. That's an ipso facto clause. But you do have to, one, cure all defaults when you assume it, and two, provide adequate assurances of future performance. So you've got to show the judge, to the satisfaction of the judge, that you can actually perform under this lease going forward. You've got the financial wherewithal, you can do it. The other thing a debtor can do, in addition to assuming, once it assumes, it can assign an agreement. So, and that's a potentially very valuable right? If you've got a lease that's important to the business, or that is under market and therefore has value, a debtor can assume it. Obviously, the defaults have to be cured, but that can be out of the proceeds of the assignment that I'm about to mention. And then can take that lease, assume it, and assign it to a third party, and effectively mine value from that lease for the benefit of all creditors. obviously there needs to be adequate assurance of future performance still, and it's not by the debtor, it's by this new third party. So when you're representing a debtor and you're doing an assume and assign, that means you've got to work with that assignee party and their counsel and make sure that you've got the factual basis to show a judge that this new party can, financially and otherwise satisfy the requirements of the lease. But you do have that right to assume and assign. There are some limitations. I mentioned that landlords have good lobbyists. Shopping center owners have very good lobbyists, and they got an amendment to the bankruptcy code put in place a number of years ago that that permits, as part of adequate assurance of future performance, it permits a landlord to insist upon maintaining the tenant mix and balance. So, as Jonathan mentioned, if you've already got a bookstore and you've got a requirement that you don't have to rent to another bookstore, that you can't rent to another bookstore, this is a limitation on assumption and assignment through adequate assurance of future performance. The landlord could stand up and say, look, I believe that this new person can pay the rent, but I'm not willing to go ahead and violate my lease with this other tenant. And before those amendments, it was unclear whether or not a landlord could do that in a shopping center environment. And it's clear now that they can enforce those tenant mix requirements. But assuming that's all complied with, now the one thing that a landlord can't do is have like a full-on consent right? The bankruptcy code overrides that. So if you've got a lease that says this lease is not assignable without the landlord's consent under any circumstances, now you're in Chapter 11, you want to assume that contract and assign it to somebody else, maybe because they're buying the whole business, or maybe because you're just selling this individual lease. You can do that, but obviously, as I mentioned, there needs to be adequate assurances and all of that. But if the lease says it can't be assigned without consent, that absolute consent right is overridden by the bankruptcy code. And that's another place where the balance is shifted towards the debtor for purposes of making sure that if there's value there that can be mined, that one creditor, the landlord, is not going to have superior rights than everybody else in the case. And if there's value, if the debtor can bring in $1,000 worth of value assigning that lease, even over the objection of the landlord, that benefits the creditor body as a whole, a bankruptcy judge will approve it. So it's pretty draconian from the landlord's perspective. Debtor also has, as I said, the right to reject a contract, has to make a motion to do it. It's subject to a business judgment standard, which is a relatively low standard, simply show that it's not a lease that is part of the company's future business model. Debtor doesn't have to comply with the lease any further. It has to surrender possession of the property, obviously. And it leaves the landlord with a claim for damages in the amount that it would be if the debtor had breached the agreement 1 minute before bankruptcy. Important to note, under leases, there is a cap. Let's say you've got a 20-year lease, right? And you've got huge future rent obligations. And if you breach that lease prior to bankruptcy, the landlord's claim would be for the full amount of the lease, subject to whatever mitigation requirements might exist under state law, duty to mitigate. What the bankruptcy code says is no, you have a claim for your back rent, you have a claim for the greater of 1 year's rent or 15% of the remaining rent due, but not to exceed 3 years. It's basically 1 or 3 years, depending upon how long the lease is. You can get a claim for those future rent obligations, but it cuts off after that. And that's just so that landlords' claims don't just swamp everybody else's rights in a bankruptcy case, and they're the only ones that get a recovery.
Audience, if you've been if you haven't been tracking, I didn't want to interrupt Mark, but I've been moving to the relevant slides as he's been referencing concepts on them. So if you're listening only, like as you're walking because you don't have anything better to listen to, that would be odd, on your iPod because you're listening in the past. I guess people live.
Who has an iPod? I don't think any.
Maybe the word something is an antique. Anyway, if you're not, for whatever reason, looking at the slides as we're moving on demand, you'll see the relevant slides displayed. Mark, finish up. We're basically out of time, but please finish your thought.
Yep, great. So as has been mentioned in the past, you've got 60 days to start complying with your leases. You have to comply with your leases and contracts during bankruptcy. We talked about that. In terms of going back to your original question, designation rights. Now we understand assumption, rejection. We understand assignment. So again, oftentimes these leases, there are leases in the debtor's portfolio that are under market and they have value. The debtor may not want them, but somebody else might, and it might be able to bring in value to the estate. So what a debtor is able to do, and there's been a practice development for doing this, the debtor has the ability to effectively sell the right to designate which leases will be assumed or rejected. Well, if it's a buyer of the whole business, obviously that makes a lot of sense, right? That party should get to decide which leases do I want to take, which ones don't I. But also it's a way for a company to monetize its under market leases, which could bring significant value in. And remember, all of this ties into the fact that, and why there's value there, it's because what the bankruptcy code does is it obliterates the landlord's right to say no to an assignment. And it creates that value. And this selling designation rights is where a debtor takes advantage of that opportunity that's been given to it by the bankruptcy code in order to mine value for the benefit of the entire estate.
Thank you. I'm going to take 60 seconds or so to just give a little description of what we would have covered if we didn't run out of time. And the reason I'm doing it is those on demand who are consuming this on demand, or if you're consuming this live, want to go back and listen to it on demand, it'll kind of give you kind of a little bit of a guide. My next question was going to put myself in the shoes of a vendor, a seller of goods to the retailer. And slides 22 through 24 get into section 503B9 and sections 546C of the bankruptcy code and the right of reclamation. That's slides 22 through 24. The concept of critical vendor status is covered on slide 27. The uniform commercial code sections of 2609 that gives a right of the vendor a right to demand adequate assurance of performance, and UCC 2-203 that gives the vendor the right to refuse delivery except for cash and reclaim when it discovers its buyer is insolvent. That's touched on in slide 28. Consignment, rather, if I'm not selling my goods to a vendor, but I'm consigning them. I was going to ask Mark about that. He was going to be brilliant in his answer. That's covered on slides 25 through 26. The other Jonathan was going to be equally brilliant, I'm sure, in talking about how if I'm a consumer and I bought gift cards and I want to use the gift cards during the bankruptcy by walking into the stores that are having those GOB sales, what's the likelihood that they'll be honored? And then on slides 31 and 32, we were going to talk about debtors that are selling not just goods in a going out of business sale, but their entire business, the name, the website, the customer list, the IP, or the entire business as a going concern. That's slide 32. And when you sell stuff like that, like customer lists and IP, customer lists and websites, you're going to implicate consumer privacy and PII laws, personally identifiable information, if I'm saying that right. That's slide 31. But we're not going to cover any of that because we're out of time. But enjoy the slide deck. And almost every issue we talked about is the subject of another Financial Poise webinar, which are available both on West Legal Ed Center on demand and on financialpoise.com on demand. James, Mark, Jonathan, thanks for joining. And this webinar is concluded.
Thank you all.